Well, good afternoon, everybody. Welcome to this month's webinar of the New Hampshire Insurance Department. My name is DJ Betancourt, and I have the pleasure of serving as the commissioner. Our consumer division here at the department, which is comprised of 7 individuals who all day, every day that they are here at the department, take in inquiries from consumers. They'll take in approximately 6,500 calls from complaints from consumers per year. Of those 6,500 calls, all but 500 of those calls are from consumers who have some sort of a question about their insurance coverage. And one of the most frequent questions that we get from consumers surrounds what the claims process for an auto claim looks like. They've unfortunately been in a wreck or some other unfortunate situation has occurred to them. And now they're trying to understand what they need to do next and understand what the protections that New Hampshire law provides to them are so that they can take advantage of them. Now, one of the things we always advise consumers, of course, is to work with an independent agent or to work with an agent. They'll be able to help you through that process. But to the extent that you're not getting the answer that you need, your agent's not being responsive for whatever reason, or you don't work with one, we hope that today's webinar will be instructive and help you understand how to approach things, what your rights are, how the process should work. And we've got our team of subject matter experts here who are going to help with that presentation. These folks are a wealth of knowledge. We think there's a lot to be learned today, and there's great value to the consumer. So with that said, I'll throw it over to James or to Doug to kick things off.
Okay. Good afternoon, Commissioner, and thank you all for attending. My name is Douglas Reese. I'm the Chief Market Conduct Examiner here with the New Hampshire Insurance Department. And with me as resources are Emily Doherty, Counsel, and James Fox, our Director of P&C Claims. So as the Commissioner alluded to, we want to talk about some of our more impactful consumer protection laws, particularly RSA 417 and INS 1002. And we'll go into these in a deep dive in some and just superficially in another. Okay, so our agenda today will be RSA 417, which provides general guidance for conduct of insurers. That's commonly referred to as the fair claims practices or unfair claims standards. We'll also talk about RSA 417D, which is aftermarket parts, INS 1002, which will break down into 4 sections, 1002.13, which is rental, 1002.15 is total losses, 1002.17 is hidden damage and the shop of choice, and a very kind of unique law to New Hampshire, 1002.19, which we call the deductible waiver. So 417 is a statute. It's often referred to as a model law or unfair claims practices. These laws were some of the first drafted, and they're referred to as model acts because they're often drafted by the NAIC and adopted in many, many other states. So this gives insurers and consumers a very broad baseline of protections in most states. So obviously today we're just going to speak about New Hampshire. So 417.4, Roman numeral 15A4, basically tells insurers that they are obligated to act in good faith to effectuate prompt, fair, and equitable settlements or compromises of claims in which liability has become reasonably clear. Give you some examples of that because that's a kind of a broad statement. Examples of this: delaying payments, asking for unnecessary or duplicate documents, asking for information not pertinent to the facts or the processing of the claim, ignoring or dismissing information that doesn't support the carrier's liability position, discrimination, withholding of policy benefit. So I'll give you some quick examples of each of those. Delaying payments, fairly self-explanatory, but a company has 5 days to make a payment when you have submitted all the necessary information. Anything beyond that is a violation of that. They can't ask you to provide duplicate information or information that's not relative to the claim. For example, if you're filing an auto claim accident, they cannot ask you for your tax returns or your mortgage statement. There are a few examples if they're doing an SIU investigation, but for the most part, that information will not make a difference in the claim. The fourth bullet point, we've seen this quite a bit lately. A good example of that would be you're involved in an automobile accident. You believe you had the right of way. The other carrier's driver says they had the right of way, and a police report is in your favor, and maybe a witness is in your favor, but the company chooses to believe or put more weight on their driver and denies your claim when, a police report or contacting a witness or going out and looking at that intersection might have yielded a different decision. So they need to look at all the information that's available to them before they make that decision. Discrimination is fairly self-explanatory. And then withholding or concealing policy benefits. If you ask for a rental where liability is clear and they say, well, we really don't think that's necessary at this point, or you don't have any coverage, and you later find out you do have coverage, that's concealing a policy benefit. So RSA 417D is aftermarket parts, and the statute defines those as parts not made by the OEM, original equipment manufacturer, and that would be, a company like Toyota, Chevrolet, or BMW. Our statute does allow for the use of aftermarket parts, providing the vehicle is over 2 years old and has more than 30,000 miles on it. So they should not be used on a relatively new car. The statute requires that they must be of equal quality to OEM and disclosed on the insurer's estimate. So you will see a footnote, an asterisk, a part number, or some acronym describing the part itself, and it might be something like AFT, NCAR for aftermarket. I skipped the bullet point there, and I just wanted, it's going to take a little time to explain, but the statute requires them to be of like kind and quality. However, if some modifications are needed to make that part fit, such as welding a bracket to it or drilling a hole for a backup camera, the insurer is obligated to pay for those modifications. At some point, if the part needs several hours worth of modification, it is probably not a like kind and quality part and should not be used. But the insurer is obligated to pay for those modifications. The statute further defines other items such as glass, suspension, tires, and batteries are not aftermarket parts. So when we refer to an aftermarket part, we generally refer to exterior components such as bumper covers, hoods, fenders, deck lids, rear bumpers. Those are what's commonly referred to as aftermarket parts. Sheet metal, if you will, but bumper covers are urethane in most cases. So that's our aftermarket parts statute. I'm going to talk a little bit about some of our administrative rules, and I think it might be a good time to have either James or Emily chime in on the difference between statutes and administrative rules, if you could.
Okay, this is James. So obviously we are the insurance department. We're part of the executive branch and we do enforcement. What we're enforcing are statutes and rules that ultimately go through the legislature. So a statute goes through the legislature through the committee process. We go to Commerce Committee, and then they pass statutes, which is for insurance is Title 37. So we view that as our laws on the statutory level. Those are the highest level. And then because statutes can't really address in detail all the different things that might happen and how to bring the statute to come to life, all the little details and how we accomplish everything, then we have a rule making process where here at the department we draft up proposed rules, we have public hearings, And then we go to something called JLCAR, which is Joint Legislative Committee on Rules. And so that basically goes through that committee. So again, we're back to the legislature. Then the legislature approves those rules, which are usually, almost always more detailed than the statute. In this particular instance, if you look at Reg 1000, which is the claims rule, that cites to, so at the bottom of every rule is the citation, that cites back to particular 417.4 a lot, because that is the unfair claims practices part of it is statute. So that's how it all works together to make sure we can protect consumers consistent with the legislative will.
Doug? All right. Thank you, James. Commonly, we address complaints about rental, substitute transportation, or rental as most people call it. Administrative Rule 1002-13 requires insurers to offer rental to claimants when liability is established. And I just want to note that some of these statutes are specific to claimant, and some of them are insured only, some of them are both, and we'll try to address that with each one. It's important to note here that they must affirmatively offer that rental. Sending a letter at the beginning of a claims process saying, if we're liable, we may owe you rental, is not consistent with the statute. They have to make the liability determined and then quickly advise you that you're entitled to a rental. You're entitled to a rental of like, kind, and quality, and you're entitled to a rental for the period that the vehicle is being repaired. Now, I wrote for some exceptions up there. Part delays are not an exception. COVID is not an exception. If your car is being repaired through a liability claim and the parts cannot be located, then you are still entitled to a rental. The only exception, or with few exceptions, if the claimant purposefully delays the repair process or drops it off at a shop and says, I'm going on vacation with your car, with the rental cross country, might be a little bit of a problem there. But generally, the most common delays are the shop just can't get to it. That is not acceptable under our law. They still owe the rental. Part delays or accessibility of parts, as we saw in COVID, are also not a reason for an exception. The insured rental, there's really no specific rule for insurance other than 417 fair claim practices or unfair claim practices. It must be prompt, fair, and equitable. The subject is really defined by the policy terms. So if you purchase 30 days at $30, then that is the contractual obligation that the insurer has while the unit is being repaired. Total loss claims, 1,215. This tends to generate a lot of questions to the office, and we deal with these quite regularly. So this is kind of a unique statute to New Hampshire, a unique administrative rule. Unique to New Hampshire is that we actually require the methodology to be filed and approved with the department. So companies like CCC, Mitchell, and Carfax are on an approved vendor list. They are the ones that determine the value, or the software that determines the value of the total loss. Years ago, you had a product called NADA, National Association of Dealers, Auto Dealers. That's still out there under the name of J.D. Powers, and it's accessible by consumers. CCC, Mitchell, and Carfax, unfortunately, do not have valuation products that are consumer facing. So it's a little different world than it was. Consumers can access Kelley Blue Book, but that is not an approved methodology with the state. Right? So one of the more common issues that we address, under 1,215 is the dispute resolution, which is actually a very good rule. Every auto policy has an appraisal clause in it, which applies to repairs, but not the value of the vehicle. The dispute resolution process will walk through it, but it is much more consumer friendly, much faster, and much more cost effective than the appraisal clause. So when a company determines your vehicle to be a total loss, they must provide a copy of that valuation report from CCC, Mitchell, Carfax, or whatever system they're using. And more recently, we have changed 1,215 to reflect that dealer document and prep fees charged should be included in the fair market value of that vehicle. And those, based on our information, can run anywhere from $200 to $600. So we'll get into a little deeper with the dispute resolution. Very common. I think it's common because people generally feel their vehicles are worth more to them personally than they are in the market. And I have a theory that if you weren't planning on budgeting for a new car on your way to work today and got in an accident and it's a total, then it's very difficult to put a value on that inconvenience, if you will. The companies are required to pay for the fair market value of that vehicle, which is what the asset would change hands for. So, very common to have a dispute over it. Very simply, in 1,215, if there's a dispute, the insured simply provides two comparable vehicles from two reliable sources. That could mean your local dealership, or it could be an online quote. Autotrader.com, Cars.com, Carfax, AutoTrader, all are legitimate sources where dealers list their vehicles for sale. It's accessible to everybody. You turn those into your insurer, and they must average them in. So you will still have deductions for mileage and option and condition, but at least you're getting your vehicles averaged in, or the ones that you best feel are comparable to your vehicle are going to be averaged in with the rest of the pool, if you will. Very straightforward process, very simple, inexpensive. No need to hire an appraiser, no need to hire an appraiser and an umpire. Can be done very, very quickly in an afternoon. I've seen some companies respond to these. Okay, 1,217, excuse me, deals with direct repairs. And insurers can have arrangements with repair shops and offer guarantees or negotiate discounts on parts, and certainly set quality standards and repair standards. However, the insurance company cannot require an insured or claimant to use a specific shop. That is steering, and it's prohibited under our law. So they can have a direct repair shop with some benefits to the consumer, but they can't force you to use it. Under 1,217, every estimate that's written basically says that if there's hidden damage, it will be it needs to be covered by the insurer. So the idea that once you get a check, there's no release on the check. The insurers can't do that. If the shop tears it down and finds damage underneath, the insurance company is still obligated to pay for that, whether it's an insured or a claimant. So recently, beginning with COVID and trying to keep people isolated, companies started offering electronic appraisals where an insured or claimant would email photos of their car to their adjuster. This is perfectly legal in New Hampshire, and it may seem efficient. However, consumers need to be aware that it's unlikely, due to the construction of vehicles today, that a photograph will capture the extent of the damage. Certainly nothing underneath, say, a bumper cover or a fender. It seems efficient. They'll write an estimate from the desk. They'll issue a payment. You can get going with the repairs, but it's more than likely that there'll be a supplemental appraisal, and that's fine. That's perfectly legal, and that happens many times even with an on-site appraisal. Our concern is that if you are not going to make the repairs, you may not be getting an equitable settlement. You consider, if you will, if you have a electronic appraisal done and it's just superficial, it appears to be superficial damage to the bumper cover, and then you trade the vehicle in and they do an actual appraisal, or if it's a leased vehicle, they tend to be a little more thorough with their appraisals. In all cases, the department recommends having a collision professional provide an estimate to make sure that you physically inspect the vehicle, open the hood, crawl underneath it, see what else is damaged behind that bumper cover or fender. Okay, so 1,217, continuing with that, insurers are required to provide an estimate that is fair and reasonable with the usual and customary guarantees as to the workmanship and material. So that's a professional shop. And they also are required to provide the name of a shop that will do the work for that appraisal. Continuing on with 1,217, if there is a dispute between your shop and the insurance company, they are then obligated to get a third quote or estimate from a shop that they are not affiliated with. So they cannot rely on their direct repair program if there's a dispute between your shop and their shop. However, as the disclaimer says, you may be eligible for out-of-pocket, or you may be obligated for out-of-pocket expenses in some cases. But it's important to realize that many times with the direct repair programs, they work very well. But the insurance company cannot rely solely on them when there's a dispute. Uninsured motorist, 1,219. This is a very unique administrative rule in New Hampshire, and it's a very good one, but we constantly see this not being done correctly on examinations. So in the event that you are struck by an uninsured motorist and they meet the three tests caused by an uninsured motor vehicle operator has been positively identified, and the operator is solely at fault, the insurer should waive your deductible. So if you carry a $250 or $500 deductible, and you're hit by an uninsured motorist, you do not pay your deductible. It should not be reimbursed after they collect back from the person or anything else. It should simply not be applied from the initial claim payment. So, very unique law in New Hampshire. If you have any questions, you certainly can contact us, email us, phone in, or give us a call. And I don't know, AJ, are we taking questions?
We have a question from the chat. Is the second bullet on the aftermarket parts slide supposed to include not allowed? Maybe we could go back to that slide and refer to that real quick.
Could be a typo.
In the meantime, we have another question. Is there a way an insurer can timely confirm part delays?
Okay, so I'm not sure what the question was, but yeah, I think I probably wrote that a little incorrectly. But basically, if the car is less than 2 years and 30,000 miles, they cannot use an aftermarket part.
Is there a way that an insurer can timely confirm part delays?
I think they'd probably just have to call their shop and talk to them and see when they were ordered. We did see that, again, very common in COVID. Everything was difficult to get, from toilet paper to fenders, so it wouldn't surprise me. But I don't know that if for some reason insured a claimant's rental is denied from the company because they're waiting for parts, and they should reach out to talk to us and call us, and we'll see if we can't work through that.
Okay. Well, we're getting close to the end here. I'll turn it over to Commissioner Betancourt for any closing thoughts.
Well, thank you so much, Andrew. And I will say I am thrilled by the turnout today. I think this is one of our best attended webinars. So that's great. Obviously, this program will also be available on our social media platforms, obviously available to folks who were not able to join us live today. A lot of information obviously covered in this presentation. Impossible for us to cover every possible scenario that could arise in any single presentation. So again, that last slide of the presentation included our contact information. Do not hesitate to give us a call. Should there be a situation that was not addressed in this event, or you need further information or detail about something that you heard, we're here to help. We are here as a resource of information to consumers, and we take that responsibility very, very seriously. So with all of that being said, again, thank you so much for joining us today, and we look forward to seeing you again next month.